Furthermore, it should be noted that the three options or formulae do not yet take into account the indirect taxes 70 and other financial contributions 71 of mining projects. These indirect taxes and other contributions are real and actual benefits enjoyed by the Filipino people and/or government. Now, if some of the quantifiable items are taken into account in the computations, the financial modeling would show that the total government share increases to 60% or higher, in one instance, as much as 77% and even 89%, of the net present value of total benefits from the project. As noted in the Ramos paper, these results are not at all shabby, considering that the contractor puts in all the capital requirements and assumes all the risks, without the government having to contribute or risk anything. Despite the foregoing explanation, Justice Carpio still insisted during the court's deliberations that the phrase among other things refers only to taxes, duties and fees. We are bewildered by his position. On the one hand, he condemns the mining law for allegedly limiting the government's benefits only to taxes, duties and fees, and on the other, he refuses to allow the state to benefit from the correct and proper interpretation of the DENR/MGB. To remove all doubts then, we hold that the state's share is not limited to taxes, duties and fees only and that the DENR/MGB interpretation of the phrase among other things is correct. Definitely, this DENR/MGB interpretation is not only legally sound, but also greatly advantageous to the government. One last point on the subject. The legislature acted judiciously in not defining the terms among other things and, instead, leaving it to the agencies concerned to devise and develop the various modes of arriving at a reasonable and fair amount for the additional government share. As can be seen from DOW 9956, the agencies concerned did an admirable job of conceiving and developing not just one formula, but three different formulae for arriving at the additional government share. Each of these options is quite fair and reasonable, and, as Messrs. Ramos and De Vera stated, other alternatives or schemes for a possible improvement of the fiscal regime for FTAs are also being studied by the government. Besides, not locking into a fixed definition of the term among other things will ultimately be more beneficial to the government, as it will have that innate flexibility to adjust to and cope with rapidly changing circumstances, particularly those in the international markets. Such flexibility is especially significant for the government in terms of helping our mining enterprises remain competitive in world markets despite challenging and shifting economic scenarios. In conclusion, we stress that we do not share the view that in FTAs with foreign contractors under RA 7942, the government's share is limited to taxes, fees and duties. Consequently, we find the attacks on the second paragraph of Section 81 of RA 7942 totally unwarranted. Collections not made uncertain. By the third paragraph of Section 81. The third or last paragraph of Section 8172 provides that the government share in FTAs shall be collected when the contractor shall have recovered its pre-operating expenses on exploration and development expenditures. The objection has been advanced that, on account of the proviso, the collection of the state's share is not even certain, as there is no time limit in RA 7942 for this grace period or recovery period. We believe that Congress did not set any time limit for the grace period, preferring to leave it to the concerned agencies, which are, on account of their technical expertise and training, in a better position to determine the appropriate durations for such recovery periods. After all, these recovery periods are determined, to a great extent, by technical and technological factors peculiar to the mining industry. Besides, with developments and advances in technology and in the geosciences, we cannot discount the possibility of shorter recovery periods. At any rate, the concerned agencies have not been remiss in this area. The 1995 and 1996 implementing rules and regulations of RA 7942 specify that the period of recovery, reckoned from the date of commercial operation, shall be for a period not exceeding 5 years, or until the date of actual recovery, whichever comes earlier. Approval of pre-operating expenses required by RA 7942. Still, RA 7942 was criticized for allegedly not requiring government approval of pre-operating, exploration and development expenses of the foreign contractors, who are in effect given unfettered discretion to determine the amounts of such expenses. Supposedly, nothing prevents the contractors from recording such expenses in amounts equal to the mining revenues anticipated for the first 10 or 15 years of commercial production, with the result that the share of the state will be zero for the first 10 or 15 years. Moreover, under the circumstances, the government would be unable to say when it would start to receive its share under the FTA. We believe that the argument is based on incorrect information as well as speculation. Obviously, certain crucial provisions in the mining law were overlooked. Section 23, dealing with the rights and obligations of the exploration permit grantee, states, the permittee shall undertake exploration work on the area as specified by its permit based on an approved work program. The next proviso reads, any expenditure in excess of the yearly budget of the approved work program may be carried forward and credited to the succeeding years covering the duration of the permit. XXX. Underscoring supplied. Clearly, even at the stage of application for an exploration permit, the applicant is required to submit, for approval by the government, a proposed work program for exploration, containing a yearly budget of proposed expenditures. The state has the opportunity to pass upon, and approve or reject, such proposed expenditures, with the foreknowledge that, if approved, these will subsequently be recorded as pre-operating expenses that the contractor will have to recoup over the grace period. That is not all. Under Section 24, an exploration permit holder who determines the commercial viability of a project covering a mining area may, within the term of the permit, file with the Mines and Geosciences Bureau a declaration of mining project feasibility. This declaration is to be accompanied by a work program for development for the Bureau's approval, the necessary prelude for entering into a mineral production sharing agreement, MPSA, or some other mineral agreement. At this stage, too, the government obviously has the opportunity to approve or reject the proposed work program and budgeted expenditures for development works on the project. Such expenditures will ultimately become the pre-operating and development costs that will have to be recovered by the contractor. Naturally, with the submission of approved work programs and budgets for the exploration and the development, construction phases, the government will be able to scrutinize and approve or reject such expenditures. It will be well informed as to the amounts of pre-operating and other expenses that the contractor may legitimately recover and the approximate period of time needed to effect such a recovery. There is therefore no way the contractor can just randomly post any amount of pre-operating expenses and expect to recover the same. The aforementioned provisions on approved work programs and budgets have counterparts in Section 35, which deals with the terms and conditions exclusively applicable to FTAs. The said provision requires certain terms and conditions to be incorporated into FTAs, among them, a firm commitment XXX of an amount corresponding to the expenditure obligation that will be invested in the contract area and representations and warranties XXX to timely deploy these financing, managerial and technical expertise and technological resources under its supervision pursuant to the periodic work programs and related budgets XXX, as well as work programs and minimum expenditures commitments. Underscoring supplied. Unarguably, given the provisions of Section 35, the state has every opportunity to pass upon the proposed expenditures under FTA and approve or reject them. It has access to all the information it may need in order to determine in advance the amounts of pre-operating and developmental expenses that will have to be recovered by the contractor and the amount of time needed for such recovery. In summary, we cannot agree that the third or last paragraph of Section 81 of RA 7942 is in any manner unconstitutional. No deprivation of beneficial rights. It is also claimed that aside from the second and the third paragraphs of Section 81, discussed above, Sections 80, 84 and 112 of RA 7942 also operate to deprive the state of beneficial rights of ownership over mineral resources, and give them away for free to private business enterprises, including foreign-owned corporations. Likewise, the said provisions have been construed as constituting, together with Section 81, an ingenious attempt to resurrect the old and discredited system of license, concession or lease. Specifically, Section 80 is condemned for limiting the state's share in a mineral production sharing agreement, MPSA, to just the excise tax on the mineral product. Under Section 151A of the Tax Code, such tax is only 2% of the market value of the gross output of the minerals. The Calatia in Section 84, the portion considered offensive to the Constitution, reiterates the same limitation made in Section 80.73. It should be pointed out that Section 80 and the Calatia in Section 84 pertain only to MPSAs and have no application to FTAs. These particular statutory provisions do not come within the issues that were defined and delineated by this court during the oral argument, particularly the third issue, which pertained exclusively to FTAs. Neither did the parties argue upon them in their pleadings. Hence, this court cannot make any pronouncement in this case regarding the constitutionality of Sections 80 and 84 without violating the fundamental rules of due process. Indeed, the two provisos will have to await another case specifically placing them in issue. On the other hand, Section 11274 is disparaged for allegedly reverting FTAs and all mineral agreements to the old and discredited license, concession or lease system. This section states in relevant part that the provisions of Chapter 14, which includes Sections 80-82, on government share in mineral production sharing agreement XXX shall immediately govern and apply to a mining lessee or contractor. Underscoring supplied, this provision is construed as signifying that the 2% excise tax which, pursuant to Section 80, comprises the government share in MPSAs shall now also constitute the government share in FTAs, as well as in coal production agreements and joint venture agreements, to the exclusion of revenues of any other nature or from any other source. Apart from the fact that Section 112 likewise does not come within the issues delineated by this court during the oral argument, and was never touched upon by the parties in their pleadings, it must also be noted that the criticism hurled against this section is rooted in unwarranted conclusions made without considering other relevant provisions in the statute. Whether Section 112 may properly apply to coal production or joint venture agreements, the fact of the matter is that it cannot be made to apply to FTAs. First, Section 112 does not specifically mention or refer to FTAs. The only reason it is being applied to them at all is the fact that it happens to use the word contractor. Hence, it is a bit of a stretch to insist that it covers FTAs as well. Second, mineral agreements, of which there are three types, MPSAs, coal production agreements, and joint venture agreements, are covered by Chapter 5 of RA 7942. On the other hand, FTAs are covered by and in fact are the subject of Chapter 6, an entirely different chapter altogether. The law obviously intends to treat them as a breed apart from mineral agreements, since Section 35, found in Chapter 6, creates a long list of specific terms, conditions, commitments, representations and warranties, which have not been made applicable to mineral agreements, to be incorporated into FTAs. Third, under Section 39, the FTA contractor is given the option to downgrade, to convert the FTA into a mineral agreement at any time during the term if the economic viability of the contract area is inadequate to sustain large-scale mining operations. Thus, there is no reason to think that the law through Section 112 intends to exact from FTA contractors merely the same government share, a 2% excise tax, that it apparently demands from contractors under the three forms of mineral agreements. In brief, Section 112 does not apply to FTAs. Notwithstanding the foregoing explanation, Justices Carpio and Morales maintain that the court must rule now on the constitutionality of Sections 80, 84 and 112, allegedly because the WMCP contains a provision which grants the contractor unbridled and automatic authority to convert the FTA into an MPSA, and should such conversion happen, the state would be prejudiced since its share would be limited to the 2% excise tax. Justice Carpio adds that there are 5 MPSAs already signed just awaiting the judgment of this court on respondents' and interveners' motions for reconsideration. We hold however that, at this point, this argument is based on pure speculation. The court cannot rule on mere surmises and hypothetical assumptions, without firm factual anchor. We repeat, basic due process requires that we hear the parties who have a real legal interest in the MPSAs, that is the parties who executed them, before these MPSAs can be reviewed, or worse, struck down by the court. Anything less than that requirement would be arbitrary and capricious. In any event, the conversion of the present FTA into an MPSA is problematic. First, the contractor must comply with the law, particularly Section 39 of RA 7942. Inter alia, it must convincingly show that the economic viability of the contract is found to be inadequate to justify large-scale mining operations. Second, it must contend with the President's exercise of the power of state control over the use of natural resources. And third, it will have to risk a possible declaration of the unconstitutionality, in a proper case, of Sections 80, 84 and 112. The first requirement is not as simple as it looks. Section 39 contemplates a situation in which an FTA has already been executed and entered into, and is presumably being implemented, when the contractor discovers that the mineral or reserves in the contract area are not sufficient to justify large-scale mining, and thus, the contractor requests the conversion of the FTA into an MPSA. The contractor in effect needs to explain why, despite its exploration activities, including the conduct of various geologic and other scientific tests and procedures in the contract area, it was unable to determine correctly the mineral or reserves and the economic viability of the area. The contractor must explain why, after conducting such exploration activities, it decided to file a declaration of mining feasibility, and to apply for an FTA, thereby leading the state to believe that the area could sustain large-scale mining. The contractor must justify fully why its earlier findings, based on scientific procedures, tests and data, turned out to be wrong, or were way off. It must likewise prove that its new findings, also based on scientific tests and procedures, are correct. Right away, this puts the contractor's technical capabilities and expertise into serious doubt. We wonder if anyone would relish being in this situation. The state could even question and challenge the contractor's qualification and competence to continue the activity under an MPSA. All in all, while there may be cogent grounds to assail the aforementioned sections, this court, on considerations of due process, cannot rule upon them here. Anyway, if later on these sections are declared unconstitutional, such declaration will not affect the other portions since they are clearly separable from the rest. Our mineral resources not given away for free by RA 7942. Nevertheless, if only to disabuse our minds, we should address the contention that our mineral resources are effectively given away for free by the law, RA 7942, in general and by Sections 80, 81, 84 and 112 in particular. Foreign contractors do not just waltz into town one day and leave the next, taking away mineral resources without paying anything. In order to get at the minerals, they have to invest huge sums of money, tens or hundreds of millions of dollars, in exploration works first. If the exploration proves unsuccessful, all the cash spent thereon will not be returned to the foreign investors, rather, those funds will have been infused into the local economy, to remain there permanently. The benefits therefrom cannot be simply ignored. And assuming that the foreign contractors are successful in finding ore bodies that are viable for commercial exploitation, they do not just pluck out the minerals and cart them off. They have first to build campsites and roadways, dig mine shafts and connecting tunnels, prepare tailing ponds, storage areas and vehicle depots, install their machinery and equipment, generator sets, pumps, water tanks and sewer systems, and so on. In short, they need to expend a great deal more of their funds for facilities, equipment and supplies, fuel, salaries of local labor and technical staff, and other operating expenses. In the meantime, they also have to pay taxes, 75 duties, fees, and royalties. All told, the exploration, pre-feasibility, feasibility, development and construction phases together add up to as many as 11 years. 76 The contractors have to continually shell out funds for the duration of over a decade, before they can commence commercial production from which they would eventually derive revenues. All that money translates into a lot of pump priming for the local economy. Granted that the contractors are allowed subsequently to recover their pre-operating expenses, still, that eventuality will happen only after they shall have first put out the cash and fueled the economy. Moreover, in the process of recouping their investments and costs, the foreign contractors do not actually pull out the money from the economy. Rather, they recover or recoup their investments out of actual commercial production by not paying a portion of the basic government share corresponding to national taxes, along with the additional government share, for a period of not more than 5 years 77 counted from the commencement of commercial production. It must be noted that there can be no recovery without commencing actual commercial production. In the meantime that the contractors are recouping costs, they need to continue operating. In order to do so, they have to disperse money to meet their various needs. In short, money is continually infused into the economy. The foregoing discussion should serve to rid us of the mistaken belief that, since the foreign contractors are allowed to recover their investments and costs, the end result is that they practically get the minerals for free, which leaves the Filipino people none the better for it. All business is entitled to cost recovery. Let it be put on record that not only foreign contractors, but all businessmen and all business entities in general, have to recoup their investments and costs. That is one of the first things a student learns in business school. Regardless of its nationality, and whether or not a business entity has a 5-year cost recovery period, it must have to recoup its investments, one way or another. This is just common business sense. Recovery of investments is absolutely indispensable for business survival, and business survival ensures soundness of the economy, which is critical and contributory to the general welfare of the people. Even government corporations must recoup their investments in order to survive and continue in operation. And, as the preceding discussion has shown, there is no business that gets ahead or earns profits without any cost to it. It must also be stressed that, though the state owns vast mineral wealth, such wealth is not readily accessible or transformable into usable and negotiable currency without the intervention of the credible mining companies. Those untapped mineral resources, hidden beneath tons of earth and rock, may as well not be there for all the good they do us right now. They have first to be extracted and converted into marketable form, and the country needs the foreign contractors' funds, technology and know-how for that. After about 11 years of pre-operation and another 5 years for cost recovery, the foreign contractors will have just broken even. Is it likely that they would at that point stop their operations and leave? Certainly not. They have yet to make profits. Thus, for the remainder of the contract term, they must strive to maintain profitability. During this period, they pay the whole of the basic government share and the additional government share which, taken together with indirect taxes and other contributions, amount to approximately 60% or more of the entire financial benefits generated by the mining venture. In sum, we can hardly talk about foreign contractors taking our mineral resources for free. It takes a lot of hard cash to even begin to do what they do. And what they do in this country ultimately benefits the local economy, grows businesses, generates employment, and creates infrastructure, as discussed above. Hence, we definitely disagree with the sweeping claim that NOFTA under Section 81 will ever make any real contribution to the growth of the economy or to the general welfare of the country. This is not a plea for foreign contractors. Rather, This is a question of focusing the judicial spotlight squarely on all the pertinent facts as they bear upon the issue at hand, in order to avoid leaping precipitately to ill-conceived conclusions not solidly grounded upon fact. Repatriation of after-tax income. Another objection points to the alleged failure of the mining law to ensure real contributions to the economic growth and general welfare of the country, as mandated by Section 2 of Article 12 of the Constitution. Pursuant to Section 81 of the law, the entire after-tax income arising from the exploitation of mineral resources owned by the state supposedly belongs to the foreign contractors, which will naturally repatriate the said after-tax income to their home countries, thereby resulting in no real contribution to the economic growth of this country. Clearly, this contention is premised on erroneous assumptions. First, as already discussed in detail here and above, the concerned agencies have correctly interpreted the second paragraph of Section 81 of RA 7942 to mean that the government is entitled to an additional share, to be computed based on any one of the following factors: net mining revenues, the present value of the cash flows, or excess profits reckoned against the benchmark rate of return on investments. So it is not correct to say that all of the after-tax income will accrue to the foreign tech contractor, as the government effectively receives a significant portion thereof. Second, the foreign contractors can hardly repatriate the entire after-tax income to their home countries. Even a bit of knowledge of corporate finance will show that it will be impossible to maintain a business as a going concern if the entire net profit earned in any particular year will be taken out and repatriated. The net income figure reflected in the bottom line is a mere accounting figure not necessarily corresponding to cash in the bank, or other quick assets. In order to produce and set aside cash in an amount equivalent to the bottom line figure, one may need to sell off assets or immediately collect receivables or liquidate short-term investments, but doing so may very likely disrupt normal business operations. In terms of cash flows, the funds corresponding to the net income as of a particular point in time are actually in use in the normal course of business operations. Pulling out such net income disrupts the cash flows and cash position of the enterprise and, depending on the amount being taken out, could seriously cripple or endanger the normal operations and financial health of the business enterprise. In short, no sane business person, concerned with maintaining the mining enterprise as a going concern and keeping a foothold in its market, can afford to repatriate the entire after-tax income to the home country. The state's receipt of 60% of after-tax contractors. After-tax income not mandatory. We now come to the next objection, which runs this way: thus with the foreign contractor, the state must receive at least 60% of the after-tax income from the exploitation of its mineral resources. This share is the equivalent of the constitutional requirement that at least 60% of the capital, and hence 60% of the income, of mining companies should remain in Filipino hands. First, we fail to see how we can properly conclude that the Constitution mandates the state to extract at least 60% of the after-tax income from a mining company run by a foreign contractor. The argument is that the Charter requires the state's partner in a co-production agreement, joint venture agreement or MPSA to be a Filipino corporation, at least 60% owned by Filipino citizens. We question the logic of this reasoning, premised on a supposedly parallel or analogous situation. We are, after all, dealing with an essentially different equation, one that involves different elements. The Charter did not intend to fix an ironclad rule on the 60% share, applicable to all situations at all times and in all circumstances. If ever such was the intention of the framers, they would have spelled it out in black and white. Verba legis will serve to dispel unwarranted and untenable conclusions. Second, if we would bother to do the math, we might better appreciate the impact, and reasonableness, of what we are demanding of the foreign contractor. Let us use a simplified illustration. Let us base it on gross revenues of, say, P500. After deducting operating expenses, but prior to income tax, suppose a mining firm makes a taxable income of P100. A corporate income tax of 32% results in P32 of taxable income going to the government, leaving the mining firm with P68. Government then takes 60% thereof, equivalent to P40.80, leaving only P27.20 for the mining firm. At this point the government has pocketed P32.00 plus P40.80, or a total of P72.80 for every P100 of taxable income, leaving the mining firm with only P27.20. But that is not all. The government has also taken 2% excise tax off the top, equivalent to another P10. Under the minimum 60% proposal, the government nets around P82.80, not counting other taxes, duties, fees and charges, from a taxable income of P100, assuming gross revenues of P500, for purposes of illustration. On the other hand, the foreign contractor, which providing all the capital, equipment and labor, and took all the entrepreneurial risks, receives P27.20. One cannot but wonder whether such a distribution is even remotely equitable and reasonable, considering the nature of the mining business. The amount of P82.80 out of P100.00 is really a lot. It does not matter that we call part of it excise tax or income tax, and another portion thereof income from exploitation of mineral resources. Some might think it wonderful to be able to take the lion's share of the benefits. But we have to ask ourselves if we are really serious in attracting the investments that are the indispensable and key element in generating the monetary benefits of which we wish to take the lion's share. Fairness is a credo not only in law, but also in business. Third, the 60% rule in the petroleum industry cannot be insisted upon at all times in the mining business. The reason happens to be the fact that in petroleum operations, the bulk of expenditures is in exploration, but once the contractor has found and tapped into the deposit, subsequent investments and expenditures are relatively minimal. The crude, or gas, keeps gushing out, and the work entailed is just a matter of piping, transporting and storing. Not so in mineral mining. The ore body does not pop out on its own. Even after it has been located, the contractor must continually invest in machineries and expend funds to dig and build tunnels in order to access and extract the minerals from underneath hundreds of tons of earth and rock. As already stated, the numerous intrinsic differences involved in their respective operations and requirements, cost structures and investment needs render it highly inappropriate to use petroleum operations as benchmarks for mining. Verily, we cannot just ignore the realities of the distinctly different situations and stubbornly insist on the minimum 60%. The mining and the oil industries. Different from each other. To stress, there is no independent showing that the taking of at least a 60% share in the after-tax income of a mining company operated by a foreign contractor is fair and reasonable under most if not all circumstances. The fact that some petroleum companies like Shell acceded to such percentage of sharing does not ipso facto mean that it is per se reasonable and applicable to non-petroleum situations, that is, mining companies, as well. We can take judicial notice of the fact that there are, after all, numerous intrinsic differences involved in their respective operations and equipment or technological requirements, cost structures and capital investment needs, and product pricing and markets. There is no showing, for instance, that mining companies can readily cope with a 60% government share in the same way petroleum companies apparently can. What we have is a suggestion to enforce the 60% quota on the basis of a disjointed analogy. The only factor common to the two disparate situations is the extraction of natural resources. Indeed, we should take note of the fact that Congress made a distinction between mining firms and petroleum companies. In Republic Act No. 7729, an act reducing the excise tax rates on metallic and non-metallic minerals and quarry resources, amending for the purpose Section 151A of the National Internal Revenue Code, as amended, the lawmakers fixed the excise tax rate on metallic and non-metallic minerals at 2% of the actual market value of the annual gross output at the time of removal. However, In the case of petroleum, the lawmakers set the excise tax rate for the first taxable sale at 15% of the fair international market price thereof. There must have been a very sound reason that impelled Congress to impose two very dissimilar excise tax rate. We cannot assume, without proof, that our honorable legislators acted arbitrarily, capriciously and whimsically in this instance. We cannot just ignore the reality of two distinctly different situations and stubbornly insist on going minimum 60%. To repeat, the mere fact that gas and oil exploration contracts grant the state 60% of the net revenues does not necessarily imply that mining contracts should likewise yield a minimum of 60% for the state. Jumping to that erroneous conclusion is like comparing apples with oranges. The exploration, development and utilization of gas and oil are simply different from those of mineral resources. To stress again, the main risk in gas and oil is in the exploration. But once oil in commercial quantities is struck and the wells are put in place, the risk is relatively over and black gold simply flows out continuously with comparatively less need for fresh investments and technology. On the other hand, even if minerals are found in viable quantities, there is still need for continuous fresh capital and expertise to dig the mineral ores from the mines. Just because deposits of mineral ores are found in one area is no guarantee that an equal amount can be found in the adjacent areas. There are simply continuing risks and need for more capital, expertise and industry all the time. Note, however, that the indirect benefits, apart from the cash revenues, are much more in the mineral industry. As mines are explored and extracted, vast employment is created, roads and other infrastructure are built, and other multiplier effects arise. On the other hand, once oil wells start producing, there is less need for employment. Roads and other public works need not be constructed continuously. In fine, there is no basis for saying that government revenues from the oil industry and from the mineral industries are to be identical all the time. Fourth, to our mind, the proffered minimum 60% suggestion tends to limit the flexibility and tie the hands of government, ultimately hampering the country's competitiveness in the international market, to the detriment of the Filipino people. This "you have to give us 60% of after-tax income or we don't do business with you" approach is quite perilous. True, this situation may not seem too unpalatable to the foreign contractor during good years, when international market prices are up and the mining firm manages to keep its costs in check. However, under unfavorable economic and business conditions, with costs spiraling skywards and minerals prices plummeting, a mining firm may consider itself lucky to make just minimal profits. The inflexible, carved-in-granite demand for a 60% government share may spell the end of the mining venture, scare away potential investors, and thereby further worsen the already dismal economic scenario. Moreover, such an unbending or unyielding policy prevents the government from responding appropriately to changing economic conditions and shifting market forces. This inflexibility further renders our country less attractive as an investment option compared with other countries. And fifth, for this court to decree imperiously that the government's share should be not less than 60% of the after-tax income of tech contractors at all times is nothing short of dictating upon the government. The result, ironically, is that the state ends up losing control. To avoid compromising the state's full control and supervision over the exploitation of mineral resources, this court must back off from insisting upon a minimum 60% rule. It is sufficient that the state has the power and means, should it so decide, to get a 60% share, or more, in the contractor's net mining revenues or after-tax income, or whatever other basis the government may decide to use in reckoning its share. It is not necessary for it to do so in every case, regardless of circumstances. In fact, the government must be trusted, must be accorded the liberty and the utmost flexibility to deal, negotiate and transact with contractors and third parties as it sees fit, and upon terms that it ascertains to be most favorable or most acceptable under the circumstances, even if it means agreeing to less than 60%. Nothing must prevent the state from agreeing to a share less than that, should it be deemed fit, otherwise the state will be deprived of full control over mineral exploitation that the Charter has vested in it. To stress again, there is simply no constitutional or legal provision fixing the minimum share of the government in NFTA at 60% of the net profit. For this court to decree such minimum is to wade into judicial legislation, and thereby inordinately impinge on the control power of the state. Let it be clear, the court is not against the grant of more benefits to the state, in fact, the more the better. If during the FTA negotiations, the president can secure 60%, 78% or even 90%, then all the better for our people. But, if under the peculiar circumstances of a specific contract, the president could secure only 50% or 55%, so be it. Needless to say, the president will have to report, and be responsible for, the specific FTA to Congress, and eventually to the people. Finally, if it should later be found that the share agreed to is grossly disadvantageous to the government, the officials responsible for entering into such a contract on its behalf will have to answer to the courts for their malfeasance. And the contract provision voided. But this court would abuse its own authority should it force the government's hand to adopt the 60% demand of some of our esteemed colleagues. Capital and expertise provided. Yet all risks assumed by contractor. Here, we will repeat what has not been emphasized and appreciated enough, the fact that the contractor in NFTA provides all the needed capital, technical and managerial expertise, and technology required to undertake the project. In regard to the WMCP FTA, the then foreign-owned WMCP as contractor committed, at the very outset, to make capital investments of up to $50 million in that single mining project. WMCP claims to have already poured in well over $800 million into the country as of February 1998, with more in the pipeline. These resources, valued in the tens or hundreds of millions of dollars, are invested in a mining project that provides no assurance whatsoever that any part of the investment will be ultimately recouped. At the same time, the contractor must comply with legally imposed environmental standards and the social obligations, for which it also commits to make significant expenditures of funds. Throughout, the contractor assumes all the risks 79 of the business, as mentioned earlier. These risks are indeed very high, considering that the rate of success in exploration is extremely low. The probability of finding any mineral or petroleum in commercially viable quantities is estimated to be about 1 to 1,000 only. On that slim chance rides the contractor's hope of recouping investments and generating profits. And when the contractor has recouped its initial investments in the project, the government share increases to 60% of net benefits, without the state ever being in peril of incurring costs, expenses and losses. And even in the worst possible scenario, an absence of commercial quantities of minerals to justify development, the contractor would already have spent several million pesos for exploration works, before arriving at the point in which it can make that determination and decide to cut its losses. In fact, during the first year alone of the exploration period, the contractor was already committed to spend not less than $24 million. The FTA therefore clearly ensures benefits for the local economy, courtesy of the contractor. All in all, this setup cannot be regarded as disadvantageous to the state or the Filipino people. It certainly cannot be said to convey beneficial ownership of our mineral resources to foreign contractors. Deductions allowed by the WMCP FTA reasonable. Petitioners question whether the state's weak control might render the sharing arrangements ineffective. They cite the so-called suspicious deductions allowed by the WMCP FTA in arriving at the net mining revenue, which is the basis for computing the government share. The WMCP FTA, for instance, allows expenditures for development within and outside the contract area relating to the mining operations, 80 consulting fees incurred both inside and outside the Philippines for work related directly to the mining operations, 81 and the establishment and administration of field offices including administrative overheads incurred within and outside the Philippines which are properly allocatable to the mining operations and reasonably related to the performance of the contractor's obligations and exercise of its rights under this agreement. 82. It is quite well known, however, that mining companies do perform some marketing activities abroad in respect of selling their mineral products and byproducts. Hence, it would not be improper to allow the deduction of reasonable consulting fees incurred abroad, as well as administrative expenses and overheads related to marketing offices also located abroad, provided that these deductions are directly related or properly allocatable to the mining operations and reasonably related to the performance of the contractor's obligations and exercise of its rights. In any event, more facts are needed. Until we see how these provisions actually operate, mere suspicions will not suffice to propel this court into taking action. Section 7.9 of the WMCP. Invalid and disadvantageous. Having defended the WMCP, we shall now turn to two defective provisos. Let us start with Section 7.9 of the WMCP. While Section 7.7 gives the government a 60% share in the net mining revenues of WMCP from the commencement of commercial production, Section 7.9 deprives the government of part or all of the said 60%. Under the latter provision, should WMCP's foreign shareholders, who originally owned 100% of the equity, sell 60% or more of its outstanding capital stock to a Filipino citizen or corporation, the state loses its right to receive its 60% share in net mining revenues under Section 7.7. Section 7.9 provides the percentage of net mining revenues payable to the government pursuant to Clause 7.7 shall be reduced by 1% of net mining revenues for every 1% ownership interest in the contractor, that is, WMCP, held by a qualified entity. 83. Evidently, what Section 7.7 grants to the state is taken away in the next breath by Section 7.9 without any offsetting compensation to the state. Thus, in reality, the state has no vested right to receive any income from the FTA for the exploitation of its mineral resources. Worse, it would seem that what is given to the state in Section 7.7 is by mere tolerance of WMCP's foreign stockholders, who can at any time cut off the government's entire 60% share. They can do so by simply selling 60% of WMCP's outstanding capital stock to a Philippine citizen or corporation. Moreover, the proceeds of such sale will of course accrue to the foreign stockholders of WMCP, not to the state. The sale of 60% of WMCP's outstanding equity to a corporation that is 60% Filipino-owned and 40% foreign-owned will still trigger the operation of Section 7.9. Effectively, the state will lose its right to receive all 60% of the net mining revenues of WMCP, and foreign stockholders will own beneficially up to 64% of WMCP, consisting of the remaining 40% foreign equity therein, plus the 24% pro rata share in the buyer corporation. 84. In fact, the January 23, 2001 sale by WMCP's foreign stockholder of the entire outstanding equity in WMCP to Sagittarius Mines Incorporated, a domestic corporation at least 60% Filipino-owned, may be deemed to have automatically triggered the operation of Section 7.9, without need of further action by any party, and removed the state's right to receive the 60% share in net mining revenues. At bottom, Section 7.9 has the effect of depriving the state of its 60% share in the net mining revenues of WMCP without any offset or compensation whatsoever. It is possible that the inclusion of the offending provision was initially prompted by the desire to provide some form of incentive for the principal foreign stockholder in WMCP to eventually reduce its equity position and ultimately divest in favor of Filipino citizens and corporations. However, as finally structured, Section 7.9 has the deleterious effect of depriving government of the entire 60% share in WMCP's net mining revenues, without any form of compensation whatsoever. Such an outcome is completely unacceptable. The whole point of developing the nation's natural resources is to benefit the Filipino people, future generations included. And the state as sovereign and custodian of the nation's natural wealth is mandated to protect, conserve, preserve and develop that part of the national patrimony for their benefit. Hence, the Charter lays great emphasis on real contributions to the economic growth and general welfare of the country. 85 as essential guiding principles to be kept in mind when negotiating the terms and conditions of FTAs. Earlier, we held, 1. That the state must be accorded the liberty and the utmost flexibility to deal, negotiate and transact with contractors and third parties as it sees fit, and upon terms that it ascertains to be most favorable or most acceptable under the circumstances, even if that should mean agreeing to less than 60%. 2. That it is not necessary for the state to extract a 60% share in every case and regardless of circumstances, and 3. That should the state be prevented from agreeing to a share less than 60% as it deems fit, it will be deprived of the full control over mineral exploitation that the Charter has vested in it. That full control is obviously not an end in itself, it exists and subsists precisely because of the need to serve and protect the national interest. In this instance, national interest finds particular application in the protection of the national patrimony and the development and exploitation of the country's mineral resources for the benefit of the Filipino people and the enhancement of economic growth and the general welfare of the country. Undoubtedly, such full control can be misused and abused, as we now witness. Section 7.9 of the WMCP effectively gives away the state's share of net mining revenues, provided for in Section 7.7, without anything in exchange. Moreover, this outcome constitutes unjust enrichment on the part of the local and foreign stockholders of WMCP. By their mere divestment of up to 60% equity in WMCP in favor of Filipino citizens and/or corporations, the local and foreign stockholders get a windfall. Their share in the net mining revenues of WMCP is automatically increased, without their having to pay the government anything for it. In short, the provision in question is without a doubt grossly disadvantageous to the government, detrimental to the interests of the Filipino people, and violative of public policy. Moreover, it has been reiterated in numerous decisions 86 that the parties to a contract may establish any agreements, terms and conditions that they deem convenient, but these should not be contrary to law, morals, good customs, public order or public policy. 87 being precisely violative of anti-graft provisions and contrary to public policy, Section 7.9 must therefore be stricken off as invalid. Whether the government officials concerned acceded to that provision by sheer mistake or with full awareness of the ill consequences, is of no moment. It is Hornbook doctrine that the principle of estoppel does not operate against the government for the act of its agents, 88, and that it is never estopped by any mistake or error on their part. 89 It is therefore possible and proper to rectify the situation at this time. Moreover, we may also say that the FTA in question does not involve mere contractual rights, being impressed as it is with public interest. The contractual provisions and stipulations must yield to the common good and the national interest. Since the offending provision is very much separable 90 from Section 7.7 and the rest of the FTA, the deletion of Section 7.9 can be done without affecting or requiring the invalidation of the WMCP FTA itself. Such a deletion will preserve for the government its due share of the benefits. This way, the mandates of the Constitution are complied with and the interests of the government fully protected, while the business operations of the contractor are not needlessly disrupted. Section 7.8 of the WMCP FTA. Also invalid and disadvantageous. Section 7.8 of the WMCP FTA is likewise invalid. It provides thus. 7.8 The government share shall be deemed to include all of the following sums. A. All government taxes, fees, levies, costs, imposts, duties and royalties including excise tax, corporate income tax, customs duty, sales tax, value-added tax, occupation and regulatory fees, government-controlled price stabilization schemes, any other form of government-backed schemes, any tax on dividend payments by the contractor or its affiliates in respect of revenues from the mining operations and any tax on interest on domestic and foreign loans or other financial arrangements or accommodations, including loans extended to the contractor by its stockholders. B. Any payments to local and regional government, including taxes, fees, levies, costs, imposts, duties, royalties, occupation and regulatory fees and infrastructure contributions. C. Any payments to landowners, surface rights holders, occupiers, indigenous people or claim owners. D. Costs and expenses of fulfilling the contractor's obligations to contribute to national development in accordance with Clause 10.1i, 1, and 10.1i, 2,